there was, and I think you accepted this, that to move that regulation to an independent body doesn't necessarily change that. It doesn't alter the fact that you can still have all those things and support that independent legal profession. If, for example, non-lawyers were involved in the regulation of advocates. So do you accept that? And if you don't, what do you see as the problem of non-lawyers, for example, being involved in the regulation of advocates?
It's a question of how and why, in my view, as much as anything else. But if you want to maintain the independence of the courts, which is fundamental, and the independence of the legal profession, then there has to be a dividing line between the courts and the executive. And that's recognised already by the Judicature Act of last year, which provides for the position of the courts and the Lord President. Going forward, if you're looking to regulation, there are various models that you can address. The model of regulation by the court is one that Scotland has maintained over a very long period of time. It's not unique to Scotland. It's a model that is employed in many of the states of the United States and elsewhere in the Commonwealth. And it does ensure direct regulation in an effective way. If you're going to have regulation by the court, you're not excluding the interest of the public or even the consumer. Because if, again, you look to the structure of the bill, the Lord President and the Court of Session in general, when looking to the regulation of the legal profession, are bound, in terms of Clause 86, to proceed in accordance with the regulatory objectives. And those are set out in Clause 1. And Professor Patterson raised the idea of, well, will the Lord President consult, will he receive the opinions of these parties? He's bound to. Because only by doing so can he adhere to the regulatory objectives. He's got to know what is in the public interest.
Now, I fully acknowledge the point you're making with regard to 86 and, in fact, the basic regulatory objectives set out in Part 1. But I'm not clear why there would be a particular problem if non-lawyers were involved in the regulation. Would that in itself cause difficulties? Given, as I think you have accepted, there is a public perception among some that there is an issue about self-regulation, not just of lawyers, but for example, members of Parliament have recently come up against this particular problem. And I just wondered if you couldn't see the analogy there.
Well, I can understand the analogy. My own view is that, first of all, we're not self-regulating. I would like to think we might be. I know, as a matter of fact, that we're not. Not everything I suggest to the Lord President is adhered to or agreed to, I can assure you of that. But that apart, there's an issue of proportionality here. I think we have to remember that, for example, in England and Wales, you've got 17,000 barristers. And that's a formidable regulatory issue. You've got 17,000 people. In Scotland, you've got a bar of 460 people. Now, we could think up a very complex model, such as a bar standards board, which they have in England. But if we impose that on a relatively small bar, we're actually going to impose what, in relative terms, is going to be an enormous overhead on the delivery of those legal services. And at the end of the day, the truth is that the customer pays the overheads. The consumer pays the overheads. So I think there's also an issue of proportionality here as well.
I accept your argument in terms of proportionality. There clearly is an issue. Which side of that argument you come down on, I think, is more of an argument. But I think there is, it's always part of it. I just wondered if any other members of the panel had anything to add in this area of questioning.
Yeah, particularly interested in what you might have to say, Mr. Marshall. Or do you adopt the arguments which the Dean has put forward, or do you detract from them in any way or add to them?
Well, I certainly wouldn't want to impinge on the workings of the Faculty of Advocates. As far as solicitor advocates are concerned, coming back to I think where the question started, the discipline of solicitor advocates was something which was very much at the forefront of the discussions when extended rights of audience were being debated in the House of Lords, when the Law Reform Miscellaneous Provisions Bill was before the House of Lords in 1990. And most of the debate was conducted by Scottish judges, in fact, who were also members of the House of Lords. And they were very keen to ensure that solicitors appearing in the Supreme Courts would be subject to the same kinds of disciplinary procedures and practices as the advocates who were already there. And largely that was the intention behind the wording of Section 25A as it became of the Solicitor Scotland Act 1980. There are some areas where there are difficulties or differences. There is clearly a very close relationship between judges and the faculty of advocates, because all the judges in the Supreme Courts are former advocates. And they are used to having a degree of informal contact and exchange, so that if there are problems, they can be dealt with in a relatively informal way, without necessarily kicking up a rug or having everything exposed or dealt with in the public gaze. And that kind of approach may no longer be thought to be appropriate, or alternatively, it may be felt that not everything has to be done in the open air. There are little issues which can arise in the context of practice, which would be just as well dealt with quietly, and people get on, rather than having a huge hoo-ha and having a big debate in public at vast expense. But having said that, solicitor advocates feel that there may be scope for changes which would achieve the original objective, which is to try and make sure that solicitor advocates are treated exactly the same way as advocates, that the disciplinary procedures, issues of conduct can be dealt with in exactly the same way, because at the moment the existing system doesn't quite achieve that, even although that was the intention. That, of course, is really where the Ben Thompson review comes in. And as I've already indicated, I think in terms of the detail of that, it would be better to wait and see what he says.
Right, Nigel Don.
Thank you very much, Convener. I'm just wondering, Mr Marshall, whether you could just tell me how many solicitor advocates there actually are, please, because I have no idea.
At the moment, there's about 250.
Thank you.
Here. Bill Butler.
Thank you, Convener. Good afternoon, gentlemen. Issues of professional misconduct by an advocate will continue to be referred to the faculty for investigation. What safeguards are in place or are required to ensure this system of self-regulation is patently fair and equitable?
I think one has to take a step back from the point when it's referred to the faculty. Any such complaint goes to the Commission. All complaints go to the Commission. And that is without exception. The Commission will then determine whether it's dealing with a service complaint or a conduct complaint, and if it decides it is a conduct complaint, it will then refer the matter back to the faculty. If the faculty didn't deal with it, the Commission would come back very quickly to ask what was going on. Inevitably, if a conduct complaint is referred back from the Commission, it is dealt with through the faculty's systems, on which there is, as you know, lay representation. And thereafter, if a complainer is not satisfied, it may be appealed or it may be referred back to the Commissioner. But it always goes back to a lay commission, whether it be a service complaint or a conduct complaint. And I would just add one further thing. There was a time in the past when judges might deal with complaints informally. That is in the past. If we have complaints, they go to the Commission.
So they are never dealt with informally?
Not anymore.
When was the last time it was dealt with informally?
Well, in my experience, if I can explain my experience in this regard, where a judge is concerned with the conduct of an advocate, he may write me a letter. If that letter involves